Tonight we're in for a treat. We've got a masterclass from one of our associate professors here at the ANU College of Law, Ron Levy. So I thought I'd just give you a bit of an intro to Ron himself. Importantly, Ron is our program director for the Juris Doctor and Bachelor of Laws programs that we have here at the college. He's also one of Australia's foremost experts when it comes to constitutional law, which is a very hot topic this year. So I'm very interested. You might have seen Ron actually in the media. He's often given commentary on constitutional law issues. So Ron's research interests include constitutional law and theory, obviously, environmental law, which is what we'll be doing a deep dive on with tonight's masterclass, human rights law and policy, Indigenous peoples and the law governance and development. And he's published a number of books addressing some of those topics. The most recent one is his book, Deliberative Peace Referendums. Without any further ado, I think I might hand over to Ron for tonight's masterclass.
Okay, thanks, Tom, and thanks, Esther. And great to see all of you who've joined us. Now, I'm going to be speaking about fixed constitutional commitments and climate change, so I'll explain what that is. Now, in 2021, the state of Victoria constitutionally entrenched a ban on fracking. If you have any questions about these terms, then save them, and I'm really happy to answer them later on. Now, just to, quickly, fracking is an environmentally relatively destructive practice for extracting natural gas from underground. So when Victoria did this, it joined a handful of jurisdictions around the world in adopting what I've called fixed constitutional commitments on the environment in particular. And now these commitments protect the environment in the Constitution to a specific degree, so a specific amount. To give you other examples, we've got Bhutan, Kenya, New York State. All of these constitutions protect, in those cases, forest cover. So, and they have a specific quantum, a specific amount. So, for example, in Bhutan, you've got to have 60% of the country covered in forest. Now, this is quite different from the wave of environmental constitutional laws that started with Portugal in the 1970s. Since then, since Portugal, then we've had hundreds, or 100 or so rather, of other countries around the world adopt constitutional environmental provisions. So they've then passed laws that can't easily be repealed or manipulated by politicians. And so that's what we mean by entrench. So Portugal then kicked off this trend of entrenchment, but many others followed suit, as I said, but it hasn't been enough. So as you can see in the graph, this is just one graph of many showing that we're in for a rough ride, essentially, when it comes to climate change. And so, what's gone wrong? Why didn't these constitutional provisions, for example, solve the problem? Well, it's not so simple. To observers of constitutions like myself, it's actually not particularly surprising that when you change your constitution, it doesn't automatically change the policy of your country. It doesn't solve the problems that we have. Usually that's because constitutional provisions are very broad and very vague, and that's by design. They're not seeking to firm up a particular policy commitment at a particular level. They're just enunciating really broad goals, aspirations, missions, for example. In the Constitution of the Republic of South Africa, we see that in Article 24, it says that there ought to be a right to an environment that is not harmful to people's health or well-being, and that people have the right to have the environment protected. So this is what I mean by very broad and vague. What do we mean by not harmful? What does protected mean? So we don't have a lot of specificity. Many other places also have rights to a healthy environment or obligations to protect and improve the environment, what have you. There's a great deal of wiggle room there, a room for other concerns, short-term economic concerns, for example, to detract from these unfixed commitments. Those are normal constitutional commitments. And why are things so broad and vague usually? Well, it's a strategy to, it's thought, allow democracy to be part of the picture. So it gives democracy room to breathe. The people, through their representatives, are meant to fill in some of the details of these broad provisions like the ones in South Africa. And that's very different from what you see in Bhutan, Kenya, New York State, and Victoria. In those places, they've actually closed off that vagueness, that breadth, as much as possible. And that's what I'm going to be speaking with you about today. Essentially, the problem with the broad and vague approach is that it can keep us mired at square one. It can mean that when we have very complicated matters such as climate change, but many other matters too, where there are going to be costs to some people and benefits to others, it's very contentious, it's politically problematic, and it's very difficult to get agreement. So when we democratize some of these commitments, we end up not really particularly having any clear agreement on what to do about a problem like climate change. So we have constant reassessment. In Australia, we had the climate price at some point, which was then repealed when the next government came into power. Now, a new government that came into power in the past year has now reinitiated a different sort of climate change approach. Now, that's the sort of thing that goes back and forth, and it's very unstable. So what if instead, just in that box that appeared, what if we had something like a constitutional commitment on climate change that's fixed? So, for example, the Commonwealth of Australia, or any other country for that matter, must achieve net zero carbon emissions or greenhouse gas emissions by 2045, something like that. So that's an example of what I would call a fixed constitutional commitment on climate change. Now, that leaves behind what I call contemporary proceduralism, which is the vague approach, the broad approach, where the Constitution and the people are sort of, negotiating on how laws should be. So that's different from what I'm talking about here. These constitutional fixed commitments, there are a lot of objections to that. So the main objection would be the objection from democracy. As I said, when you have a broad, open-ended constitutional provision, then the people themselves and their representatives can sort of figure out democratically how to fill out those provisions. But that's not really possible if you fix things at a particular level by a particular date. So how do we justify FCCs, fixed constitutional commitments on climate, for example? Well, there are a few ways of looking at, why we might want these fixed commitments. The first one, and the one that I find the least satisfactory, is that we are in an existential emergency. We have to act. We have to act drastically, because taking drastic measures is the only way to solve the problem. So curbing democracy or curbing rights in the name of protecting ourselves fundamentally from catastrophe, well, that's something that a lot of people would agree with. A lot of environmentalists would take that view. The idea is that being, existing comes before well-being, existing well. This is a concept that if you take law in Australia, you'll learn about in a famous case called the Communist Party case. Now, the problem with this view is that, well, when exactly can we give up our democracy or our rights in order to save ourselves? And by saving ourselves, by giving up democracy or rights, do we damage ourselves anyway? Does that give up what's essential to our state, our sense of who we are as a people? Do we usher in our own destruction by giving up, democracy or rights? So that's why I say that first argument is not very satisfactory. Fixed constitutional commitments as justified by existential emergencies, it's not very satisfying. We don't know when it would apply. We might destroy ourselves and what makes us special in the first place. But there are other reasons which I think are better for having these fixed constitutional commitments. And these, which you see here as 2A and 2B, are much more satisfying. And what the argument here is that you've got fixed constitutional commitments basically saving democracy. They're democratic correctives. So, for example, the first point here is that we are correcting malrepresentation. You can see that recent figures in Australia, Canada, France, many other Western countries and other countries as well, have very strong support for significant, including costly climate change mitigation measures. So 70 to 80% would make significant sacrifices to mitigate climate change. So Now, at the same time, in places like Canada, the United States, and Australia, until very recently, there's been very little legal change in a positive direction on climate change mitigation. So that means that there's a malrepresentation. There's a mismatch between the representatives and what they're doing and the people and what they want. And that's been the case for a long time. So maybe fixed constitutional commitments can correct this malrepresentation. If elected representatives are doing a strikingly poor job of representing citizen preferences on the climate, for example, then, given that overwhelming popular support for action, then maybe, maybe we need to take action over the heads potentially of those democratic representatives. The democratic representatives don't necessarily know better than the people on this. In fact, it's the opposite. The people themselves are actually making what seems to be the more rational judgment. And the problem is that legislative democracy, representative democracy, is often very poorly able to address things like climate, like that as I said before, are complicated and costly to deal with. Many representatives in our political system tend to think of their real constituents as, let's say, businesses that underwrite their electoral campaigns. Now, that's not just a rhetorical point. There's empirical study on that to show that donations, for example, to parties steer what they decide when they're in power. So that's where the mismatch comes from. Now, if we then have fixed constitutional commitments on the climate that essentially force climate action to take place by a certain year, then that's the sort of thing that maybe can overcome that malrepresentation. And by the way, the malrepresentation is not just between representatives and the people, but also between those who are alive today and those who are going to be alive in the future. We call this the intergenerational sort of malrepresentation, because presumably there are going to be many more people in the future affected by what we do right now, more people than are alive today. And so we actually have to look after the interests of those people. And so that's another kind of malrepresentation. So maybe FCCs, fixed constitutional commitments on the climate, can correct that malrepresentation. So the other point, 2B, is the point of constitutional indecision. And here the idea is that the law can move a range of disputes out of the domain of the public and the political and promote determinacy and finality. This comes from a guy named Gerald Bustamante, who's a legal theorist. And when you go to law school, one of the key courses that you take is the legal theory course, where you learn about, what is the purpose of law? How is it supposed to work? And so on. It occurs that it's actually pro-democratic. It's positive for democracy to tie up certain really contentious problems so that we can move on. So if we tie up the question of like whether we should take action on the climate and how much, then once we've done that, we can finally get to the nitty-gritty work of making policy decisions on climate change. So a democracy that can't move beyond priority setting, beyond square one, is unable to go on and deliberate about policy specifics. And that's where the more numerous questions of policy usually take place, in the specific area. So if we fix constitutional commitments on climate, for example, then perhaps we can finally move on to taking concrete steps. And this is the sort of thing that's been studied, for example, in the European Union, where they had a so-called emissions trading scheme, which never really got off the ground until governments finally agreed to make the emissions trading scheme very firm, and until they indicated to businesses and to individuals that this policy was here to stay. And once that happens, then that brings sort of security to investors, and they're able to sort of make decisions with a sense that things are not going to be, the carpet is not going to be pulled out from under them. So many ideas throughout theories of law about, tying up certain things, sacrificing some of our ability to make decisions in one place so that we can make other decisions in other places. So this idea of fixing our constitutional decision or indecision by having fixed constitutional commitments entirely out of left field. The idea ultimately is that we widen the degrees of freedom that we have to make decisions about law and policy when we have these fixed constitutional priorities, securing some of our basic priorities. So we can't take this idea too far. Always, when you hear from an academic such as myself, when we make a claim, we never want to take things so far that we risk overstating our case. And so, the problem with what I've just said is that it's potentially problematic to tie up decisions in the Constitution for the reason that I said before, which is that it suppresses democracy to some extent. On the other hand, though, we really have to consider whether modern liberal democracies are failing to address certain very difficult problems. Can they take coherent action on long-term problems that are very complex and that potentially will benefit future generations more than ourselves? So let me quote from a very pained speech that Joe Biden gave in the United Kingdom shortly after he took office. He's defending liberal democracies, but he's calling on them to do better. So he says, "I believe we're at an inflection point in world history, the moment where it falls to us to prove that democracies will not just endure, but they will excel as we rise to seize the enormous opportunities of a new age. We have to discredit those who believe that the age of democracy is over, as some of our fellow nations believe. We have to expose as false the narrative that decrees of dictators can match the speed and scale of the 21st century challenges." So what he's saying here is that, look, other people are saying democracy is not able to rise to these challenges. But he disagrees. He thinks we just have to make democracy work. And fixed constitutional commitments on the climate would be an example along that sort of genre of democratic correction, in keeping with what Joe Biden is saying here. So to sum up, can democratic systems address challenges like the climate that are complex, based on science that very few people understand, open to misunderstanding, misinformation, disinformation? The climate issues to exploit the weaknesses of democracy. So perhaps we need new tools to avoid the policymaking quagmires that we've seen very often in relation to climate, for example, that keep people in government from addressing certain chronic problems adequately. So the best solutions will be the ones that don't concede defeat and democratic decline, but that invent new ways to support democracy, I would say. So fixed constitutional commitments can aim at democratic repair work. If they're successful, they may demonstrate that democratic societies can still be responsive to emergencies and to fix problems that are addressing us at least as well as democracies can be. So that's all I wanted to say. In the next slide, we have a link, or essentially a citation to the article where I wrote all of this. And if you're interested in learning about it further, you can certainly go and look at that. It's freely available online.